What is constitution? Constitution in the context of any country can be defined as the supreme law of the land which enjoys special legal sanctity. I don't need to emphasize the significance of law in any civilized society. It is difficult to think of a civilized society without some kind of law or some kind of legal system in its center. A society cannot qualify to be called a civilized society unless the society has developed some kind of means and mechanism to enforce, to define and to enforce their mutual rights and obligations or duties between the individuals and between the communities. Every individual should know what he can do and what he cannot do. While he enjoys certain rights, then he is supposed to respect the similar rights of others. Similarly, every community in that society should enjoy its collective rights, but at the same time, it should assume the responsibility to respect the similar rights of others. So, unless you have some kind of means and mechanism developed in that society to first of all define the mutual rights and obligations between individuals and communities, and secondly, to enforce such rights and obligations, it is difficult to think of a peaceful and stable society. This is what is done at the macro level by the Constitution. Is the point clear? Constitution is the supreme law of the land. The moment I say supreme law, it signifies that there can be other laws as well, out of which Constitution is supreme. It means other laws are there, but no law can be juxtaposed with the Constitution in terms of status. Or it means that all other forms of laws are subsidiary to the Constitution. Supreme law of the land. Then I said, it enjoys special legal sanctity. It means its sanctity is special. It is greater as compared to other laws. Now, in the next stage, I am going to establish what are the reasons behind the special legal sanctity of the Constitution. Clear? Up to this point, I have discussed that Constitution in the context of any country can be defined as the supreme law of the land which enjoys special legal sanctity. Then I discussed that every civil society, every civilized society is invariably characterized by some kind of laws, or the legal system. In some societies, the legal system or the law may be simple. In other societies, complex legal system. But every society, even a tribal society is characterized by some kind of law based on their tradition, custom, value system to govern the rights and obligations of individuals and communities. And in a modern democratic welfare state, you have a law. Such law also defines mutual rights and obligations, but the life is complex. That's why legal system is also complex. Point is clear. I have discussed this point. So constitution in the context of any country can be defined as the supreme law of the land which enjoys special legal sanctity. What are the reasons behind special legal sanctity? There are mainly three reasons which impart special legal sanctity to the Constitution. First, it is the Constitution and Constitution only which, as the supreme law of the land, provides for the establishment of the government and defines and determines the comparative jurisdiction of three wings of the government: legislature, executive and judiciary. It is the Constitution and Constitution only. It cannot be done by other laws. It is done by the Constitution only. That Constitution provides for the establishment of the government, and Constitution provides for the distribution of powers among the three wings of the government. It provides for equation of relationship between the entire government on the one hand, the authority of the government on the one hand, and rights of people on the other. So it means the Constitution as the supreme law of the land provides that very doctrinal foundation on which the edifice of entire polity rests. This is the first reason, major reason behind the special legal sanctity of the Constitution. Second reason which imparts special legal sanctity to the Constitution is the fact that all other laws are subject to scrutiny by the Constitution. Constitution is not subject to scrutiny by other laws. Other laws means laws which are enacted by the union and state legislature on those subjects which have been placed under union list or state list or concurrent list in their respective jurisdiction. Union and state legislatures, union legislature and state legislatures have been empowered to enact laws, statutory laws. These are known as statutory laws. Then delegated legislation. In day-to-day life, it is not feasible, not practical for the legislature to assemble and to enact law or laws as and when required by the administration. So therefore, legislature shares a part of its legislative authority in favor of bureaucracy or administration and allows the bureaucracy and administration to frame smaller rules, regulations, bylaws, on their own, because they are more proximate to the ground realities and situation. Such laws are known as delegated legislations or bylaws. Getting a point? So be it statutory laws enacted by the union and state legislatures or the smaller bylaws, rules, regulations, etc., delegated legislation associated with bureaucracy, or for that matter any customary law, a law which has its point of origin in the custom, tradition and value system of the society, which has continued over a long period of time. All such laws are subject to scrutiny by the Constitution, which means that such laws can survive as long as they are compatible with the provisions of the Constitution. If any law enacted by union or state legislature is found to be inconsistent with the principles or values of the Constitution, is found to be inconsistent with any direction given in the Constitution, or it is violative of any provision of the Constitution, to that much extent it can be declared as unconstitutional by the Supreme Court. and it will not be enforceable thereafter. So, what I mean to say, that all other laws are subject to scrutiny by the Constitution. But Constitution is not subject to scrutiny by other laws. That's why Constitution is the supreme law of the land. Third reason behind the special legal sanctity is this, that Constitution has been given to this country by the people themselves. The point of origin of the Constitution is not Union legislature. The word we, the first word we, the people of India, the first word we is important, very, very important, and it imparts a kind of sacrosancy to the Constitution which is not available to all other laws. It means we, the people of India, we have given to ourselves the Constitution, supreme law of the land. We, the people of India, constituted that Constituent Assembly, which was entrusted with the task of designing a constitution, framing a constitution for the people. And it did so. It means the point of origin of the Constitution is not the Parliament, not even the Constituent Assembly. It is we, the people of India. Constituent Assembly did exercise authority in principle given to it by the people of India. So people of India, they are the ultimate repository of all authority. The first word we, Constituent Assembly, acted on behalf of the people of India. Are you getting a point? Constitution was framed by the members of the Constituent Assembly, but while doing so, they were exercising authority on behalf of the people of India. So the first word we is very, very important. It carries that stupendous, consensual strength and that gravity, that sacrosancy. That Constitution has been given to this country by people themselves. These are the three reasons behind the special legal sanctity of the Constitution. I repeat, first, it is the Constitution and Constitution only which has established the government and which provides for the distribution of powers, authority and responsibility among the three wings of the government. It also determines the equation of relationship between the authority of the state on the one hand and rights of people on the other. The second reason behind the special legal sanctity is this, that all other laws are subject to scrutiny by the Constitution, but Constitution is not subject to scrutiny by other laws. And the third reason behind the special legal sanctity of the Constitution is this, that it has been given to the country by people themselves. The first word, we. That imparts a kind of sacrosancy to the Constitution which is not available to any other laws enacted by union or state legislatures. Clear? No doubt, Constitution is the supreme law of the land. It means entire politico-administrative system of the country. The political leadership, you talk about president or prime minister or chief justice of India, it means union legislature, executive and judiciary, state legislature, state executive, it means entire judicial system, executive wing or legislature, every single administrative agency that you know, entire politico-administrative system, all such institutions and their functionaries, they do exercise authority or they do perform their role, within the broader bounds of the Constitution. Constitution is the supreme law of the land. And within the bounds of the Constitution, we live our lives. It means the rights that we enjoy, our legal rights or fundamental rights or duties, and on the other hand, authority of the state, any institution, the equation of relationship between the two. All such things depend on the Constitution. It means Constitution as the supreme law of the land has provided a boundary within which we do exercise, our institutions do exercise their authority, and we enjoy our rights. In case of any conflict between the authority of the state and the rights of people on the other, that dispute settlement mechanism is also there. Within mechanism has been provided by the Constitution. Supreme Court, High Court, such institutions have been established by the Constitution. Are you getting a point? That's why we can safely say that all of us live our lives within the bounds of Constitution. And who is the guardian of the Constitution? Who is responsible to protect the Constitution? So you have Supreme Court. Constitution as the supreme law of the land has provided the means and mechanism for its own protection and for its sustained enforcement. Supreme Court is the guardian of the Constitution. Supreme Court is responsible to ensure that entire system functions within the broader bounds of the Constitution, and the equation of relationship of the system of governance, the equation of relationship between the system of governance and the society at large, it is kept and it is sustained in keeping with the fundamental principles and values and the intent expressed in the Constitution. Getting a point? It means our Constitution, or any good Constitution, being the supreme law of the land, generally provides some kind of means and mechanism for its own protection, some kind of internal means and mechanism to sustain itself. A good Constitution is very much like a Tanjore doll, which means it has inbuilt means and mechanism to stabilize itself. Even if anybody or any institution tries to tilt it to its own advantage or convenience, Constitution has means and mechanism to identify that and to apply correctives and to punish those who dare to challenge its authority or who dare to manipulate with its provisions to one's own advantage. That is the beauty of a good Constitution. Point is clear? So, Constitution is the supreme law of the land which enjoys special legal sanctity. And as the supreme law of the land, it determines the very nature, content, character, and orientation of our polity. Whether it will move towards a welfare state or a warfare state. Warfare state is practically no more possible, but to make you understand, I'm just giving an example. So whether the entire polity will have tiltation towards socialist ideology or towards capitalist ideology, it will be a welfare state or something else. It will be a democracy only in terms of structure, and monarchy in content, or democracy in content and structure as well. So it means the nature and content orientation of the polity, everything is decided to a great extent by the Constitution. I mean to say, the Constitution provides a basic doctrinal disposition wherefrom the government operates. There are certain things which cannot be tampered with. So government, political leadership can frame policies. Political leadership can frame policies in keeping with its ideology, in keeping with the promises the political party would have made to the society, but nowhere the policies can transcend the boundary of the Constitution. Yes, if the political leadership acknowledges the necessity of amending any part of the Constitution, because the Constitution may over a period of time, Constitution or a particular part of the Constitution may become obsolete over a period of time because of the changes which which have taken place over a long period of time. So there can be necessity for amendment of the constitution. That can be done by the political leadership. There is no doubt about that. But in the given situation, laws cannot be enacted, or policies cannot be framed, or no administrative action can be taken which is not consistent with the provisions of the constitution or the principles and values of the constitution. So therefore, constitution as the supreme law of the land can be said to be something which provides a unity of direction and purpose to the entire government and to the entire society. Point is clear? It would be a monumental folly and mistake to define constitution merely as document of laws. Wrong. Constitution is not only a document of laws. Constitution is much more than that. If you go through the constitution, and if you are qualified enough to read and study things hidden between the lines, then you will come to realize the whole philosophy of governance while going through the constitution. Constitution is not merely a document of laws. It is an ensemble of will and aspirations of society. But think about independence. Following the independence of the country, the people would have so much of the aspirations that in the independent India, now we will have our own government, and this government will work for our welfare and development. All forms of exploitation will come to an end. For getting a point, what the people of India would have thought following the independence of the country. So founding fathers of the constitution would be under huge, the moral and ethical pressure, you can say, to design a constitution which could resuscitate the common mass from the clutches of exploitation they have been over a long period of time. Getting a point? So constitution is not merely a document of laws. Constitution is an ensemble of will and aspirations of society. What are the things that they expect from the constitution? Social justice, economic justice, political justice. Our government would respect our rights, or firstly, they would confer on us certain rights. So we will have our own domain of liberty and freedom, wherein there will be a possibility for the expression of our talent. There will be possibility for our dreams, for the expression of our dreams, our aspirations. We will be provided with the basic facilities, the health, the education, everything, so that even our children could grow, to become a good citizen, contributing to the process of growth and development of the country. So Constitution is not merely a document of laws. It is an ensemble of will and aspirations of society. It grows with the growth of society, and it dies with the death of society. Constitution is like a living organism. It's very much like a plant. It grows or it dies. It keeps evolving, either to the positive side of evolution or the negative side, but it never remains static. Constitution is very much like living organisms, like plant. If your society is dynamic, then society will keep amending the constitution from time to time to make it equally dynamic. And in that society, constitution will never become a liability. And if the constitution is dynamic, it will bring a positive change or qualitative transformation in the life of the people. Are you getting a point? Because any constitution, howsoever good it may be in terms of its content or doctrinal, the firmness, howsoever good a constitution may be in terms of its principles, values, doctrines, it cannot hold same amount of relevance for all time to come. It's very simple to understand. The constitution, and within the bounds of the constitution, the political administrative system, it all operates within a society. And the society never remains static. Our society is constantly evolving. Our perception of things do undergo changes. This is right, this is wrong. What used to be so much wrong 20 years ago, now it is not so much wrong, or it is acceptable. And after 5 or 10 years, you will find society starts celebrating the same. So society's perception of right and wrong, undergo changes from time to time. The criterions which the society apply to judge the things as acceptable or not acceptable, it means the criterion that society apply to decide whether such governance is good or not so good. So definition of good governance also undergo changes as the society evolves. So when everything is constantly evolving, how can a constitution which was designed in 1950s can hold same amount of relevance in 2020 or in 21st century? So it is required to be amended from time to time. Getting a point? This is the principle of constitutional dynamism. But constitution cannot make itself dynamic. Constitution is required to be amended. Provisions of the constitution is required to be interpreted by the judiciary progressively, so that it never becomes a liability, so that it synchronizes with the changes taking place in the contemporary realities. So please remember, Constitution is the supreme law of the land, but Constitution is not our ultimate goal and purpose. Our ultimate goal and purpose is to establish a welfare state based on social justice, economic justice, and political justice. Howsoever good a constitution may be, it cannot be an end in itself. It can be only means towards an end. So if it is found that the constitution which was working so well 20 years or 40 years ago, now the same constitution or certain principles or certain values defining the content of the constitution have now become impractical, or they are not instrumental in furtherance of the cause of society, its welfare, development, security, or if there are any limitations in the constitution in the wake of changing realities of the time, then a progressive society, a dynamic society would not hesitate at all in changing such provisions of the constitution. Our ultimate objective is welfare, protection, security, and a qualitative transformation in the life of the people. Our ultimate objective is not to treat constitution as something like a sacrosanct or which cannot be changed, which is like शाश्वत सत्य जिसमें किसी प्रकार का कोई परिवर्तन नहीं होता है. ऐसा नहीं है. हमारे संविधान के अंदर भी कुछ सिद्धांत और मूल्य ऐसे हो सकते हैं जो इतने बुनियादी हैं कि उनके प्रभाव और उनकी प्रासंगिकता में किसी प्रकार का कोई बदलाव समय काल परिस्थिति के अनुसार नहीं होता है. लेकिन फिर भी परिधि पर बहुत सारी ऐसी बातें हो सकती हैं किसी संविधान में जिसमें कि समय काल स्थिति के अनुसार बदलाव की आवश्यकता होती है. और इसके so therefore constitution is required to be amended from time to time so that it remains relevant to the society. Enough. Thank you very much. What is constitution?